together to ensure that people who have behavioral health care needs really are able to assert their rights, which ironically are in fact in law, around their access to housing. And so we're going to be hearing today from 3 experts who have worked for a number of years in the field of housing, but not just housing that's affordable, specifically housing that's affordable and safe for individuals with behavioral health care needs and the unique issues that they have. So I'm going to briefly introduce to you the 3 folks who we'll be hearing from this afternoon. First, we'll be hearing from Pam Cohen, who's in the middle. We're not in the order here. She's a staff attorney with Disability Rights California, which some of you might remember as PAI, or Protection and Advocacy, based in Sacramento. She's worked previously as an independent consultant that focused on legal and policy issues on community-based care for older adults with mental disabilities, fair housing law, and international mental health law. Over the past 10 years, Pamela has also been an adjunct professor at the New York Law School and teaches students in the areas of mental health and disability law. The first one next to me here is Maria Funk, who, when I worked at LA County Mental Health, was the housing lady. And so for me, she's still the housing lady. Maria Funk is the district chief of Los Angeles County Department of Mental Health in the section called Countywide Housing, Employment, and Education Resource Development, or CHEERD, the CHEERD division. In this role, she's responsible for developing and managing the LA County Mental Health Department's wide array of housing resources for clients who are homeless and overseeing service programs that target that population. And then lastly, you'll be hearing from Kim Savage. She provides legal representation, technical assistance, and training in the areas of land use and zoning and civil rights for nonprofit affordable housing developers and program providers. One of the roles that she's played most recently and in collaboration with LA County are really helping look at Los Angeles issues related to civil rights. She specifically has provided technical assistance in a number of California cities in amending their codes to comply with fair housing laws. So many of them, they all have a rich history that I'm not going to read all of it about, but know that we're in good company for housing expertise. And I know that our behavioral health care field is really interested in prioritizing and finding ways for us to expand capacity. So this hopefully will help us understand the extent to which law is or isn't on our side when we're trying to do that. So thank you. Please welcome our 3 guests.
Hit the arrow. Look at that. Hi, everybody. I'm Pam Cohen. I'm a staff attorney at Disability Rights California in our Sacramento office, previously in our Oakland office as of almost a year ago. I moved to Sacramento. Happy to be here today. I'm going to give you just an overview of the legal landscape for what some of the rights are that come into play when we're talking about housing for people with behavioral health needs, and then these 2 housing ladies here are going to talk about more about the specifics. I do want to mention that Disability Rights California provides free legal representation to people with all kinds of disabilities, including mental health disabilities, and that we only represent people with disabilities. So I have to be careful when I give presentations like this not to be giving legal advice to anybody else. There's my disclaimer right there. So this is just an overview of what the 3 of us are going to be talking to you about, and we're going to leave plenty of time for questions at the end. I'm going to kind of give you, like I said, an overview of what the laws are, and then Maria will give you some strategies that the county's has used for addressing citing concerns, and then Kim will talk about advocacy strategies, more from the housing provider standpoint, for overcoming impediments to housing. So very broadly, you can break the legal rights that we're talking about down into what I considered 3 categories. One is rights in licensed facilities, which we're not going to talk about today. So that would be any kind of, like a licensed board and care, a licensed adult residential facility, any kind of licensed hospital, nursing facility, any place. People will have rights in those facilities based on the licensing rules. And it's not so much, I mean, it's housing because you're living there, but it's not what we're considering housing, which is community-based housing. So it's a whole other set of laws, and I just wanted to flag it right now that it's something that we're not covering. What we are covering is a little bit about fair housing rights. So if you're a tenant and you have a mental health disability and you go to get housing, what kinds of laws can help you just in that sort of one-on-one landlord-tenant type of situation. And then the other is zoning and land use rights, which is what we're going to explore a little bit more fully, which is how zoning and land use processes can affect people with all kinds of disabilities, in particular people with behavioral health needs. So we're going to start with the one-on-one landlord-tenant type of situation, and this also applies to people who are purchasing homes as well, but for your clients it'll mostly be people who are landlord-tenants, so I'm just going to use that as the example. So both state and federal law, and I'll show you in a minute which state and federal laws, prohibit discrimination against people with all kinds of disabilities in the sale or rental of real estate by landlords, sellers, realtors, mortgage lenders, also homeowners associations, and housing authorities. And these are just some kinds of discrimination that the law protects against: refusing to rent or sell, refusing to provide mortgage or realtor services, realtors are covered too, making discriminatory statements, in the application process, in the advertising process, refusing to make reasonable accommodations and modifications in housing, and I'll talk to you a little bit more about what that means. These laws apply to most housing providers and people involved in the sale of real estate. The state laws apply to almost everybody. The federal law, and they're parallel to the federal laws. The federal laws generally do not apply to individual homeowners who have private houses. But one thing that applies to everyone, even under federal law, is making discriminatory statements. So the people who are protected by these laws are people with disabilities. And this is a definition up here of what a person with a disability is under state and federal law. It's someone who has a physical or mental impairment which limits a major life activity or a major bodily function. Under federal law, it substantially limits. Under state law, there's no substantial requirement. Or has a record of having that impairment, or is regarded as having that impairment. And these are just these are the main laws that protect against discrimination in housing. The Federal Fair Housing Act, amended in 1988 to include people with disabilities. Section 504 of the Rehabilitation Act, which applies to housing that receives federal funds. And the Fair Employment and Housing Act, which is similar but a little more inclusive to the Fair Housing Act. So talking about reasonable accommodations and modifications, failure to make reasonable accommodations and modifications is a type of discrimination, just like discriminatory statements would be failure to rent, refusal to rent to someone because of a disability, harassment, retaliation. That's all discrimination. By the way, that kind of discrimination also includes asking questions in the application process that are designed to find out whether someone has a disability. So landlords cannot ask, do you have a disability? Or even a question like, are you able to live independently, which would elicit whether you had a disability. Landlords can ask whether questions that will show that you can pay the rent or that you can handle the dwelling, but only if they ask everyone, not if they just ask people who they think has disabilities. But reasonable accommodations and modifications are a very big source of legal rights for people who have all different kinds of disabilities. And the difference between reasonable accommodations and reasonable modifications in the housing context is, and this is a little different in different kinds of discrimination, so I'm talking about the housing context. Reasonable accommodations are changes in practices or policies for people that people need because of their disability. So one big example that comes up a lot in housing is a waiver of a no pets policy for somebody who needs a psychiatric service animal or an emotional support animal, for example. Those accommodations are, if there's any cost, usually there's not a cost associated to them, but if there is a cost associated to them, it will be paid for by the housing provider. Reasonable modifications are physical modifications to the premises, like a ramp or a grab bar, which aren't so common when we're talking about housing for people with behavioral health needs. Those modifications are paid for by the tenant, except if it's federally funded housing, and then they're paid for by the landlord. But if you're representing or you're working with or you are people with mental health, behavioral health challenges, you're going to be talking mostly about reasonable accommodations. So this slide I took from the Law Foundation of Silicon Valley with their permission, because I think it's kind of cute. It's the Reasonable Accommodations Dance. And the acronym works out kind of sort of well, you'll see. So this is how the reasonable accommodations work. First, you have to have a disability covered by the laws, which is what I just defined for you. Then the individual has to request the accommodation, not necessarily in writing, although we all lawyer people always prefer things to be in writing with a very nice paper trail. Thank you very much. There are no magic words that you need to use, but it's really nice if you use the terms reasonable accommodation and maybe even Americans with Disabilities Act. And we have publications on our website that have sample reasonable accommodation requests and various contexts and doctor's letters and things like that. The accommodation has to be necessary. In other words, there has to be a nexus between the disability and the accommodation, meaning you need the accommodation because of your disability. And a landlord can request that this be supported by doctor's note, but not your entire medical record with permission to speak to the doctor. Just a note that says, this person, I have seen this person, she has a disability that, for example, requires a psychiatric service dog, and so please let her have a psychiatric service dog in the apartment. And we often see that landlords and other people requiring more documentation than they're allowed to require, so keep an eye out for that. Especially, they're not allowed to have you sign a release to talk to the doctor. The cost of the accommodation can't impose an undue burden on the party that's providing the accommodation. This isn't really usually a big problem for the kinds of accommodations that people with behavioral health challenges need. And the effect of the accommodation can't be a fundamental change to the program or service provided. So sometimes we see that coming up when there's housing that's associated with services and there's a certain kind of program and you don't fit into your client, the tenant doesn't fit into the, for example, substance use program that's being offered because they don't have a substance use issue. And then the question is, are they eligible? And maybe, sometimes you can work that out as an accommodation, but sometimes it would just be a fundamental alteration and it's not the right housing for them. And I can answer questions about any of this later. So that's mostly what I want you to know about things to keep an eye out for about whether someone is potentially being discriminated against, either directly through a refusal to rent or discriminatory statements, or by failure to provide a reasonable accommodation, things to think about. So now we get into the issues that I think people tend to talk less about, but are equally as important, which is land use and zoning issues. Because rights to housing are broader than just an individual tenant and an individual landlord having a tussle about whether they're being discriminated against or whether they're being accommodated. they have larger implications for communities that sometimes are planning or not planning to meet the needs of a larger group of people, including people who are economically disadvantaged, people who need particular kinds of housing, for example, supportive housing, to address behavioral health challenges. So zoning in general is designed to identify issues that communities need to address when they're growing, and to meet the needs of the people and the businesses that are living and operating there, and to project what needs to happen in terms of future services, and then to establish goals and policies for redirecting and managing growth. And this is important because there are public participation opportunities at every stage of this process, or almost every stage of this process, that you'll hear more about. This isn't just politics for the sake of politics. These are public processes that are designed to be public, and there's opportunities here to have a hand in what communities are doing. So land use and zoning ordinances provide for housing to be allowed in a particular area, either by right, which means you just build there, you don't have to do anything, by a permit like a conditional use permit, by a variance, or by rezoning, which rarely happens. And except for by right, all the other processes require all the other types of land use require some sort of process. Maybe it's just an application and you get an answer. More often there's a hearing and the neighbors are notified that there's going to be a hearing, and sometimes when it's a controversial issue, there's publicity, and sometimes it gets ugly. And this happens, this is NIMBY, not in my backyard. And when you're talking about supportive housing in particular, which we'll talk about in a minute, there's a lot of NIMBY problems out there. And so the two housing ladies are going to talk to you about different types of strategies for how to deal with those NIMBY issues. But this is the kind of thing that we're talking about now. Rather than individual landlord-tenant tussles, we're talking about potentially a bunch of neighbors and potentially the government getting together to try to keep people from living where they want to live. So this is California's definition of supportive housing. So supportive housing is permanent in the sense that there's no limit on the length of stay. It's not intended necessarily for people to live in this one particular place forever, but it can be permanent. There's no limit on the length of stay. It's occupied by the target population, which in this sense is people who need housing and supportive services, mental health services, substance use services, case management services, whatever services that apply, and it's flexible about what they are. And it's linked to on-site or off-site services that assist the resident in retaining the housing, improving his or her health status, and maximizing his or her ability to live and, when possible, work in the community. So the focus is on maximizing people's independence, and in flexibility in services that are individually targeted to what the person needs. An important tenet of supportive housing is that the housing and the services are separate in the sense that you don't need to comply with service requirements in order to keep your housing. So a tenant in supportive housing will have landlord-tenant rights, and then the services will come in on top of that, and you shouldn't be threatened to lose your services to lose your housing if you decide that you want to change your service plan or not comply with something. And so that's one thing to keep in mind. If someone's in supportive housing and they start saying, well, if you don't take this medication, your lease is going to be threatened, that shouldn't be happening in supportive housing. So in terms of land use, we have SB 2 from 2008, which requires local zoning codes to treat transitional and supportive housing as a regular residential use of the property, just like a house would be. A lot of planners don't know about this, even though it's been around since 2008. But it's important to know that if someone's having trouble citing a supportive housing development, and they're being treated differently than they would be if they were trying to site a house there, this comes into play. So there are roughly parallel state and federal processes for making sure that land use plans, local land use plans, account for targeted groups of people that need to be accounted for. And those groups include people with disabilities. And so in California, it's the general plan, which has what's called a housing element. There are various elements to a housing plan, and one of them is the housing element. And there are lots of requirements to a housing element. Basically, they have to assess the housing needs for different populations, including people with disabilities, and then identify what resources and what restraints apply to those needs, determine goals, policies, and objectives, and then prepare action programs, and then go back next. Whoop, did I step on something? Oh, well, that doesn't look good at all. I'll just keep talking. I have this way with technology. Are you going to help me?
I'm going to try.
I didn't do it, I swear. I was just standing here, right? Minding my own business. Look at this, we got a guy back there, we got a guy up here, thank you. I'm usually not this well taken care of technologically. I appreciate it. Okay. So all this planning has to be done, and then you have to go back next time and see how you did. And all of that requires public participation, and there are rules in the law about public participation, and people need to know that if they're having issues, they should, from the very beginning, be involved in these planning processes. And then there are similar processes that the federal government requires if any HUD money is housing and urban development money is being used. And the outline looks kind of similar to the housing element. And you need to certify to HUD also that you are affirmatively furthering fair housing. And those rules are kind of changing now. It's kind of interesting. They've been revised recently, and so we're sort of in this new era of figuring out how we're going to be able to use those federal rules to promote supportive housing in particular. And deal with NIMBY issues. So these are the kinds of not in my backyard issues that can come up with housing, roughly broken down to actions by neighbors and actions by local government. Actions by neighbors include your intimidation, your threats, your harassment. These are very difficult to deal with because, first of all, these individuals all have First Amendment rights. And you're now up against their First Amendment rights. I could just keep going without it. I have the...
We'll try one more.
You guys, on the other hand.
Thanks.
They remember themselves. I broke the hotel.
Neighbors aren't
Not this
Oh,
problem,
really?
but a different problem.
A different.
Because they brought videos and they weren't able to show them.
Oh,
because they
no.
weren't comparable.
Well, these people in charge.
Yeah.
I want me to keep talking here.
Keep talking about it.
I'm just going to have a seat and talk to you. Those slides weren't that interesting anyway. Where was I? I'm close to done also. Yeah, and it's hard to show discrimination by people who aren't housing providers. So, it's something to think about, but it's hard. It's hard to fight the neighbors directly. Neighbor buyouts is a bit of a exception. There have been situations where neighbors have gotten together to buy pieces of property so that group homes wouldn't site there, and that's a little bit easier to fight because that's so glaringly horrible. But still not a done deal. More details on all this are available, by the way, and I'll tell you where in a minute. And then actions by local government. Now, those are easier to fight from a legal perspective because the there's so many laws that apply to the government. There are various kinds of siting barriers, which will be talked about more, and these include restrictions on the number of people that are living together, spatial separation requirements, like you can't have group homes more than a certain distance apart or less than a certain distance apart, or a certain number of mental health facilities or places that provide mental health services within a certain distance of each other, or a certain number in a certain area is what I'm trying to say. And then what I call pretextual health and safety restrictions, like if a group home comes in and all of a sudden it becomes unsafe to have that number of people in a house because, like, oh my goodness, the traffic will be impacted, when in fact the people don't necessarily drive and there's no traffic problem to worry about and it's not that many people. And there have been a lot of cases that have struck down those kinds of rules because they're not really health and safety requirements. It's a pretext for keeping the group home out. And then, I list here, and this is in the materials too, so if you have the materials, you'll have this PowerPoint. Talking about some of the other different laws that talk about citing issues, where you can challenge citing issues, but I don't really think we need to go through that right now. Because it's not something you want to read from. You can get summaries of it in the materials. One thing I want to talk to you a little bit about is the ADA's, the Americans with Disabilities Act, and its integration mandate. It's not directly related to housing specifically. It's the Americans with Disabilities Act, but it does apply to people with behavioral health challenges and where they end up living. So raise your hand if you know about the Olmsted case. Okay, so not everybody. Okay. So the Americans with Disabilities Act is like what I just talked to you about with the Fair Housing Act. It prohibits discrimination against people with disabilities in various settings, including discrimination by governmental entities, which is Title II of the ADA. And in 1999, the Olmsted versus LC, in Olmsted versus LC, the United States Supreme Court held that unnecessarily institutionalizing people with mental health disabilities, in this case, developmental disabilities and psychiatric disabilities, unnecessarily segregates them from the non-disabled population and therefore is a form of discrimination under the Americans with Disabilities Act. And this has really changed the way that the system looks at placement of people with disabilities. What it means is that government funds, state, local government funds, cannot be used to keep people in institutions when, oh, thanks. So there's the ADA. Governmental benefits like Medicaid, for example, Medicaid money, cannot be used to provide services to people in institutions when the individual's treatment team thinks they could be in the community, when they want to be in the community, and when it's not unduly burdensome for them to be in the community. And that, of course, is the issue. Is it too expensive? But there's all kinds of case law and rules that I'm not going to go into right now about what's unduly burdensome and what needs to be taken into account. But it's a very important right to know about. And on Monday, for example, I have a hearing where I'm trying to get somebody with brain injuries out of a hospital where he's just being warehoused because the Medicaid agency won't place him in the supported living that I've arranged for him because they think it's too expensive but it's really not, and the only alternative is inappropriate institutionalization. So that's like one way that you can use the Olmsted case. So these are the three reasons, the three criteria for Olmsted community integration. So like I said, it's not housing in particular, but if you're talking about someone who would otherwise be institutionalized, it can make the difference between being an institution and being in supported living or some type of housing where someone can receive services. So I just did a little bit of slide because I'm a lawyer about administrative and legal remedies. If there are clients with behavioral health challenges who run up against these problems, they can call Disability Rights California, and we provide free advice, and then sometimes more than advice, depending on what the issue is and what our resources are on these kinds of issues. Whoops. And this is a paper I wrote under a Cal Mesa grant last year. It's called It's called Everyone's Neighborhood, Addressing Not in My Backyard Opposition to Supportive Housing for People with Mental Health Disabilities. It actually applies to people with various kinds of disabilities, but I was writing it under a mental health grant, so that's the title of the paper. And this has all kinds of resources at the back on all the various issues that I've been talking about, and it outlines all the laws I've been talking about. It talks about the housing elements process and the federal consolidated planning process and public participation and all of that. And there are a few copies available over there, and I put the link in the materials. So I'll hand this over to the housing ladies now, and thanks.
So hi, again, my name is Maria Funk, and I'm not certain how I got on 2 panels, but somehow that happened. And I have to tell you that when I was asked to be on a panel about the law is on your side, I thought, what in the world am I going to talk about? I'm the housing lady, I guess, but I'm not the legal lady. And in fact, I'm a clinical psychologist, so I really felt like I really didn't have a lot to contribute. But I realized that what I could share with you is what we in LA County have done to really acknowledge that siting could be an issue and how we've addressed and created systems to deal with that. But then I also realized that, what we do is we collaborate with people who are the legal people who know how to address these issues. So when I was invited, I said, well, what about, let's invite Kim Savage, because she's the legal lady. We work with her, and she's worked with us and provided technical assistance on some of the issues that we've addressed, and she could tell you kind of really how she has addressed the issues that have come up. So I'm going to talk to you about the structures we've created that allow us to address siting issues, and then she can share. Part of what she'll share is some of the work she's done for LA County. So, really in LA County, as we did our initial planning for MHSA back in 2005, we realized that siting was an important issue. Our stakeholders did. And they had the foresight to know that we needed to be thinking about those issues. And because we knew that we had a lot of MHSA money that now was going to be coming into the community, and that was that we would be creating new programs, and the programs would have to be sited in their communities. After that, in 2008, we also developed the MHSA housing program, statewide program, was developed, and we started it in LA County in 2008, and we knew that we were investing $115 million in building new permanent supportive housing, and again, siting issues could arise as we're trying to develop new housing projects. So the stakeholders, we set aside $80,000 when we did our initial MHSA planning. I don't think we had any idea how we were going to actually use the money, but let me tell you how we ended up using it. So we had 4 different strategies that I'm going to briefly talk about today. One is we developed a siting manual. We did training on how to address siting issues. We provided siting technical assistance, and then we also encouraged people in our community, consumers or family members or other people, interested stakeholders, to go to these public hearings that were just talked about so they could talk from personal experience to try to get the community to embrace these projects. So I'm going to talk a little more in depth about each of those. So the first thing is we hired an agency called Government and Community Affairs Strategies. This was a national public affairs firm in the area of land use, public relations, and citing controversial projects. And we hired them to develop a manual for us on successful citing strategies that we could then share with the people in our system that would need to use that information. So the citing strategy manual included tools to use, so people could actually have tools to use when they're citing projects, best practices, and then also we included a section on just the DMH, our county processes that are required maybe by our Board of Supervisors or that we wanted people to use when they were going to cite projects in their area. So first, I just want to make sure that I say that this is the citing manual, and I brought some. They're over here. I brought them in a suitcase today, so please take them if you want them, because I don't want to take them back with me. But when we developed this actually in January 2009, we made a lot of copies, and they're sitting in my office, so I said, okay, I'm going to bring some with me. So this, and also this is online, and you can see there where it says the www.dmh.lacounty.gov, and it tells you how to find it. You can download this if you're interested and want to use any of the information. But the manual contains information on all these different topics. So, you know, things from tips on how to create a community outreach plan, preparing a lobbying plan, holding an open house, you know, having good neighbor agreements, anti-NIMBY tools, strategies for working on the consolidated plan, some of the things that were just talked about. So all those things are in this manual. Basically, they did research to see what was out there and consolidated it into a manual for us. So after we developed this manual, we did trainings on citing issues. And so during those trainings, part of the purpose was to introduce the manual to our stakeholders, to people that would need to use it. The trainings included education about citing strategies. They included vignettes so people could practice, you know, talking in a public hearing type setting, what they would say, what kind of things they could do in those settings. Even I remembered even talking about just verbal cues or you know, cues that people have when they're talking and how to know what to do when they see those things from the community. We also had during those trainings presentations by people such as housing developers or other mental health providers that had to deal with citing issues in their communities to talk about what they learned and how they dealt with certain issues. And then we also provided information about a new resource we were creating on technical assistance that would be available to them when they needed it in addressing a citing issue. So that's what I'm going to talk about next, is that we provided an opportunity for citing technical assistance for any of our providers, either whether they're mental health providers or housing developers. So the way we did this, in case you're interested and work for county bureaucracy, this is what we did. We had a request for a statement of interest to identify experts. And the experts we looked for were in 5 different categories: affordable housing development, public relations, land use and zoning, fair housing laws, and development financing. So people that thought they had expertise in these different areas, they responded to us. And from their responses, we developed a master agreement list of eligible people that had this expertise. We then, again, educated our provider community that this resource was available, and we developed a guideline and procedure for people to request this technical assistance. So we have, on the one hand, this list of experts that people can contract with, that we, the department, would contract on their behalf. And we created a system for people to say, I need this help. Will you, the county, help us have technical assistance and pay for it? So we decided that we would pay for up to $10,000 per project for this technical assistance. And basically the provider who needed the assistance would make a request to us and let us know what kind of assistance they thought they needed. And then we would look at our list of experts and say who could provide that expertise to this provider who needs that help. So based on that expertise that was needed, we would ask the providers that had that expertise to do a work plan, and then we would select which one was the right one based on certain criteria. So We would select the expert, we would contract with them, we would create a work plan, a statement of work, and a fee schedule, but basically the consultant would work directly with the housing developer, whoever it was, who needed that assistance, and to help resolve the issue. So we kind of paid the bills while they provided the expertise to help the provider. So these are just some examples of requests for technical assistance that came into our department. The first one was a new transition age youth permanent supportive housing project, but what ended up happening with that is the project never got off the ground, and so that project was discontinued, so we never actually provided the technical assistance. We also had we have what we call institutions for mental disease step-down programs, or IMD step-down programs, and we had a new project that was going to be starting and focused on a criminally involved population, and there was a request for assistance with community outreach and researching relevant laws to ensure compliance. So that was another example. And then we had two other projects. One was, they were both through the MHSA housing program. One was a TAY project and one was an adult project. And again, they wanted help to develop a siting strategy, community outreach, and then just researching the relevant laws and ensuring compliance. So I think at least 3 of these actually Kim helped us with, or maybe at least a couple of them. And so she'll probably talk a little bit about some of this work she did and specifically what she did, but these are just examples of how we have used that money. So then the last thing we did is we just tried to create a place for people that we could call upon, that when we knew there was a public hearing, when we knew there was some community resistance to a project, that we could ask to attend the hearings, to talk about their own experience, maybe their own experience of living in permanent supportive housing, or their own experience of their family member who may be homeless, who needs housing, and just to be part of that community process. Really also looking for people who live in the same community as, the community that had the concerns, to be part of those discussions. And then also in our department, we have what we call our MHSA Housing Advisory Board, which is made up of various stakeholders, including family members and people who have lived experience, and that we also encourage them to be part of those meetings or hearings. And they have been, actually, and did help some of our projects go forward. So the only other thing I'm going to say is, to be honest, that this resource has not been used that much, and I'm not certain why. And so we have some great examples where we've helped get our projects moving along that were stuck. But it really hasn't been used a lot. And unfortunately, sometimes with our MHSA housing program, projects that we have already invested in, we hear after the fact that the project is no longer going forward because of community resistance, and they never called upon us to be part of that discussion. So they just tell us after the fact, we don't want your money anymore, because the community did not support this project for people with mental illness. And unfortunately, at that point, they've already changed their population and pulled out. So we might have more discussion about that. I don't know if other people have found that. But now I'm going to turn it over to Kim.
Thank you. I'm Kim Savage. I have a private practice representing affordable housing developers, those who are developing housing and treatment programs for individuals with disabilities. I work statewide. Few people in this room are individuals and organizations that I have worked with and continue to work with. Prior to this, I was a legal aid attorney. I think I've been a houser from birth. I worked on slum habitability cases, redevelopment cases designed to basically protect and create affordable housing. I then worked for National Senior Citizens Law Center, a national backup center, and did housing work there. And then prior to starting my own practice, I worked for mental health advocacy services in Los Angeles, where I represented both individuals who had housing problems and also got into the whole land use and zoning area for the purpose of both prohibiting housing discrimination and also furthering housing opportunities for individuals with disabilities. So I tell you that because I feel like, I probably can relate to each one of you in this room who either works with individual clients, develops housing, thinking of developing housing because your clients really need it. So I kind of work with both individuals as well as organizations. I just want to say something about Los Angeles County's commitment to trying to further siting opportunities and housing for individuals with disabilities. Their commitment to having various approaches to assisting in that process, I think, is really great. Their commitment to making technical assistance available to nonprofits is very important, because many nonprofits just cannot afford to basically pay for a lawyer to help them go through the process. And sadly, too often, to get housing developed, you need to have a lawyer involved because of opposition coming from various directions. I think that there's that what LA County did provides a model for other jurisdictions. And I would really encourage those of you who have any ability to see that that can happen in your jurisdiction would be great, particularly in view of the fact that we have crisis residential funding coming through. And as you know from MHSA and from your work, that you can have a whole lot of money, but you can't get the housing developed unless you can get through a land use and zoning process and deal with opposition. So I would really encourage you to try to do what LA County has done. I think it's really going to be helpful to get crisis residential and other kinds of housing developed, whether it's permanent supportive, transitional housing, and everything that falls in between. My purpose today is to kind of have you walk away with understanding the big picture, understanding that you need to know the basics of land use and zoning before you develop housing. You need to know what's permitted and not permitted, and whether that is actually what a local government is saying is actually legal based on fair housing and other laws. And maybe you'll get a basic understanding of how to manage community opposition that arises, and just understanding basically the rights to develop housing in the community. There are numerous siting influences. I've listed the 4 that I think are the kind of the general category. Obviously, we have federal and state legal protections, and we have municipal land use and zoning. They're not always consistent. We have elected officials that we have to deal with on various levels. And there are community organizations, neighborhood stakeholders. And then we have housing planning, state and federal requirements, which can influence and actually help you. And Pam has referenced that. And then I refer to this as, I often, when people ask me what I do for my work, I kind of explain it being a 3-ring circus. But as you can tell, I think it's much more than a 3-ring circus. There's a lot going on when you're trying to develop housing, or expand your housing, or even just rehabilitate and renovate your housing. And a lot of these, these elements, these moving parts can be very helpful to you, which I'll talk about a little bit later in terms of your board, your staff, and the 6 degrees of separation. Local governments, you're frequently dealing with a lot of different departments. You might be dealing with planning, building and safety, there might be design review, there might be a disability access department that could help you. There's a lot of complicated things when you're developing housing. Elected officials, state licensing is up here for a particular reason. As Pam said, we're not really talking about state licensing, but one thing that I want to point out is there are individuals who are developing housing that is not subject to licensure, but could be challenged by state licensing. As you know, when state licensing is related to a facility where you are providing care and supervision to individuals who need care and supervision. But if you create an independent living situation, but it has all sorts of elements that could be interpreted as providing care and supervision. You might have state licensing knocking on your door and suggesting that you go start the licensing process. I bring this up because it has happened multiple times with some of my clients who are developing independent living situations in the community. We have neighborhoods, separate from that, we have neighborhood groups, associations. As far as I know, almost every city has something like neighborhood councils, neighborhood associations that are advisory, in name only, and have a lot of influence with elected officials. So this is just an overview of the kind of constraints to housing that arise through land use and zoning regulations and procedures. We have actual regulations that are written down that might be discriminatory based on one of a number of legal theories. There are regulations or statutes that you read that on their face single out and discriminate against housing for individuals with disabilities. Maybe something, most of these have disappeared, but not completely. So it could be, years ago, there would be something that would say that city's ordinance would say that group homes for individuals with developmental disabilities are not permitted in single-family residential zones. They're only permitted in high-density residential zones. Well, that's something that's right on its face, meaning when you read it, it's discriminatory. Today, the discrimination is much more subtle, and I'll talk about this a little bit later, where you read something and on its face, it does not single out housing for individuals with disabilities, but it either has a greater impact in restricting or prohibiting housing for people with disabilities, or it might be an ordinance or regulation that's neutral on its face, but maybe it's only being applied against housing for individuals with disabilities. And I'm going to talk about a San Jacinto case at the end, which will provide an example of that. There are also practice impediments, those that are not written, and I discovered that when I was hired by the City of Los Angeles to review their zoning code. Pretty thick and pretty complicated, and had some problems. And I did some interviews as well as read the code, and found that there were a lot of unwritten practices that needed to be talked about, needed to be discussed in this study because they were having a negative impact. They were restricting housing for people with disabilities. So I refer to them as practice impediments. And then part of the whole land use and zoning picture is just how the planning approval process goes. Is it operating as it should, or is there some bias in it? So these are examples of potentially discriminatory land use and zoning provisions. I'm going to talk, you didn't talk about Adamson, right? Okay, so I'm going to talk about a case that's been around for a while, and I wasn't really going to talk about any cases, but I think it helps explain these two prongs, and it's a pretty important theory for lawyers to use and for you to know about. There was a case from the 70s in the city of Santa Barbara where about 15 people, college, post-college age students, were living together in a big house. And at the time, the city of Santa Barbara had a definition of family which said that a family is people related by blood, marriage, or adoption, or no more than 5 unrelated individuals. Well, think about that definition in terms of a group living arrangement for people with disabilities. It means no more than 5 individuals with disabilities who are unrelated can reside together. That is a very important case, City of Santa Barbara versus Adamson. It's the California Supreme Court case, and it basically threw out definitions of family that distinguished between related and unrelated individuals, and any capping of the number of unrelated individuals who could reside together. It's a very important decision, and it could impacts many housing opportunities, group living, congregate living arrangements for people with disabilities who choose to reside together. I'm talking about a type of living situation that is not subject to licensure, where there's a single-family dwelling and a group of individuals who have disabilities and are unrelated reside together. So that definition of family was thrown out, and it's had very favorable results in terms of trying to cite. It's been very effective for citing sober living homes and allowing individuals well beyond the number of 5 to reside together and go through a clean and sober living environment. So that's what the first 2 prongs are about. The third prong, I'm sort of like a mea culpa on this. I don't know how this came out this way, because this is sort of wishful thinking. Right now, throughout the state of California, in almost every jurisdiction, a conditional use permit requirement is imposed when you have more than 6 individuals in state licensed facilities residing together. You guys all probably know the six and under rule for state licensed facilities. So this bullet point that I have here is sort of wishful thinking, but it is more than that in that imposing a conditional use permit for any kind of state licensed facility for 7 or more is really a significant barrier, because for any of you who operate them, you know that it's really hard to make it financially if you only have 6 residents in a community care facility or a state licensed alcohol and drug program. But most states impose this very expensive, costly, and potentially uncomfortable conditional use permit process. The Department of Justice actually believes that this is discriminatory, but we don't have a case right now for that. So read that third bullet cautiously, and I need to revise it. However, the fourth bullet is important, because often if you look at a city's activities in terms of land use and zoning, you need to look at it citywide. And if you look at your city's zoning code and you see that there is no place that you can cite housing for people with disabilities without a conditional use permit, your local government's got a problem. And through the housing element work, the planning documents that Pam talked about, you need to be raising these things. This next prong, mischaracterizing group homes for individuals with disabilities as boarding houses, is a really key thing that I have run into a lot. Neighbor looks across the street, sees that people are coming and going. It doesn't look like a, traditional family, as if there really is a traditional family now of a mom, dad, and 2 kids and the dog. But and they don't know what it is. So the neighbor calls up the city, calls up code enforcement. Code enforcement comes out and doesn't know what it is and cites it as a boarding house. And boarding houses typically are not permitted in single-family residential zones. So that's a really common mischaracterization. Use definitions that distinguish between physical and mental health. You might find this in your local zoning code, where your government defines hospitals and then has another definition for LA, I can tell you this, LA had, until I did this study and we got some changes, had a definition for a general hospital and a definition for the mentally deranged and drug addicted. And this was as recent as 1995, something like that. So you never know what you'll find if you read the zoning code. Spacing requirements, Pam mentioned, although there is one under state law for state licensed facilities, they are typically frowned upon and considered violations of fair housing laws. Neighborhood notification outreach requirements. Most jurisdictions have these. There is no legal requirement. There's nothing under the law which requires neighborhood notification. I think many of us have just decided that we want to be a good neighbor. We want our projects to go forward. But I think it's important to look at those carefully and see what kind of barriers they pose for developing housing. Most large jurisdictions that I know have some sort of notification requirement that is built right into their RFPs. I think they're very problematic. It's, you know, kind of trying to get the politics out of the process of siting. And then reasonable accommodation procedures. I'm going to talk about this a little bit more, but under California law, we are really ahead of the game compared to many other states. Our government code has a requirement that local governments both analyze the land use and zoning impediments to developing housing for people with disabilities, and also to adopt a reasonable accommodation procedure. So it's a very important piece of legislation that we got through in, I think, about 2001. So every city and county in the state of California should have a reasonable accommodation procedure that can be used in the land use and zoning process to get exceptions so you can move your project forward in some way that is a deviation from what is required by the code. And I'll talk about that a little bit later. Pam talked about the conditional use permit process. Has anybody gone through that with the project? One brave soul? Only one? Okay, well, there's a reason for that probably. Was it two? Two, okay, good. All right, so as Pam explained, there's a public notice and hearing process. The public notice means that there's a rule, a regulation about how far the notice has to be. It's usually, you know, neighbors within 500 feet, neighbors meaning both the property owners and all the renters. It means they get notice of the hearing and they can come and exercise their First Amendment right and say whatever they want about your project, about you, about your clients, about your organization. Aside from that, that gets to take place at the public hearing. However, the process must be free from discrimination. And I've given you just some things to think about if you are brave and go through the conditional use permit process, or you're not brave and feel like you have to get your project approved. You really need to watch very carefully how the hearing is held. And I would suggest that if you are going to one of those hearings, that you bring somebody with you who can take notes, because if you're speaking at it or you're organizing people to speak in support of your project, you can't take notes, and it's really important to take notes on who says what. The planning decision must be based on legitimate planning factors. Size of the project in relationship to the surrounding buildings, the scale, the footprint, parking requirements, those sorts of things. The aesthetics should not be entering into it. The people who is going to be living in the housing is not supposed to be the subject of the determination as to whether the conditional use permit is granted or not granted. And there needs to be a written decision which explains why what conditions are being imposed and why they are, which leads me to one of the technical assistance project I worked on for the County of LA, which was the David and Margaret Youth and, it's got a very long name, David and Margaret Youth and Family Services. So they are a social service organization that has a beautiful plot of land in Laverne, which is northeast of Los Angeles. And they have state licensed facilities there, and they wanted to expand and develop an affordable housing project, primarily for, I think, 25 individuals and then 10 families. Not licensed, permanent supportive housing. I worked on this from the aspect of making sure that the information about the project went out in an understandable way, provided enough information, but not too much information which might somehow jeopardize or compromise the privacy rights of the individuals who would live there. And that means specifically not saying what kind of diagnosis anyone would have or background or anything like that. And things actually went along fairly well because David and Margaret had been in the neighborhood for 100 years, and they had a beautiful piece of land, and they had a place to build this. The reason I'm bringing this up now is because when the city proposed the conditions, because a conditional use permit was required, there were 3 problematic conditions, which I think we were able to resolve successfully. One was that the police department wanted to be involved in developing the tenant selection criteria. We got rid of that one pretty quickly. That was not a tough one. A tougher one was surveillance cameras connected to the local police department. So, the client was, well, let's say I was more protective because I knew that that was unreasonable. The client is often wants to acquiesce more. This is why you want to have a lawyer sometimes, because the client knows who's, funding their project, needs to approve their project, and so you don't want to bite the hand that feeds you. So the lawyer can play the, difficult person as long as they have the law on their side, which is what this is all about. And so we were able to work that out, that surveillance cameras, that's fine, but we didn't want them feeding into the police department. And I would object to that no matter what kind of housing or who was going to live there. But I was particularly concerned with the transitional age youth. Very concerned that something could be picked up on camera that the police would want to get involved in, and yet the provider would be able to resolve much more successfully as a mental health provider. So I think the resolution on that was that they would have the cameras, but they would not feed into the police department. And I think there was one other condition that I was a little concerned with. Oh, they wanted, the city wanted an annual review, which is really typical for a lot of cities. They want you to every year come back and show that you're complying with the conditional use permit and every condition. And I can tell you, for having to do that with one client on 2 different projects, it's very expensive for the client, who's a nonprofit, and it's very time consuming. So I don't remember how that came down on that condition, if we kicked that or not. But that did come up, and that's really typical. But like all conditions, there needs to be some basis for it. Additional lighting, additional security shouldn't be based on some kind of stereotype about what the individuals who are living in the building are going to be like. And if you permit those kinds of conditions to be imposed, it probably means that you're going to have to come up with some more money to pay for all those things. So looking at the conditions is a very important part of the process with a conditional use permit. The other thing I want to mention is that although the public gets to say whatever it wants, exercising its First Amendment rights, if elected officials don't get to. And also, elected officials do not get to make their determination on a planning approval matter based on discriminatory statements and unfounded kind of accusations about, your clients who are going to live in the building. So that's another reason to be really careful if you go through this process and listening who's saying what. So for citing strategies, I mean, you want to respond to legitimate concerns of the community. And that means sometimes having to kind of dissect those objections and figuring out, now, why is that person really saying it? Are they mad at their elected official because they feel like their neighborhood has been forgotten, or do they really oppose our project? So you have to listen to what those concerns are and figure out where they are coming to and whether you can respond to them. Obviously, you're all going to maintain the respect for the rights of current tenants, prospective residents, and having done this for so many years, I describe this as trying to neutralize the opposition. I don't think that I can really convince people that they have a discriminatory mindset. So the idea is to neutralize opposition. And what you're trying to do is really advance a variety of housing opportunities for individuals with disabilities in the community. So I came up with this very simplistic little 5 W's, just like I think we did this in elementary school or something when we were writing reports, pretending we were news reporters or something. The first is, trying to figure, as you're going through this process, you're going to figure out how are we going to deal with the community, locating this piece of property, how are we going to deal with approval processes and elected officials and whoever else is out there that may slow down our project or try to prevent it from going forward. You want to figure out who is the community, what are the concerns, when do you begin communications, where and how do you begin to engage the community, and why does any of this matter if you have a legal right to site and develop in this location. So this is my idea of who the big community is. And it's good to try to go forward not having any preconceived notions about who will or who will not be on your side, because in the last 5 years, I've had 2 churches loudly protest my clients' small developments, and I was completely shocked. So one never knows where your support will come from, where your opposition will come from. But you need to sort of figure out who's out there in the community, who's impacted, who might feel impacted. There are, as Pam mentioned, and I mentioned earlier also, there are legitimate concerns and those that are just kind of based on myths and stereotypes, and there are stacks and stacks of studies out there that directly respond to the question, the challenge that affordable housing increases crime and affordable housing lowers property values. And included in affordable housing is permanent supportive housing and other types of housing for people with disabilities. Those 2 allegations have just been refuted in stacks and stacks of studies that are readily available that either of us, all 3 of us, could provide you. It doesn't mean that the assertions are not continue to be made, but there are a lot of findings that it's completely incorrect. And in fact, a lot of studies now show that permanent supportive housing just really helps bring up the neighborhood. So, some of these are legitimate, some of these are not legitimate. So in terms of when you start talking about your project, let me just say that what I'm talking about here now is this is not a recipe where you just kind of go down the list, check it off, and you're done. Every single time you cite something, there's a difference. There's a variable, something you didn't account for, you didn't experience before. But it all depends on where you're citing. Are you a newbie doing this? What's your relationship with the elected official? I would say one of the key things is to get and stay ahead of any kind of rumors that are out there. And I believe that in always being just completely honest about what you're developing and not trying to hide the ball and and sneak in the middle of the night. Some of this I've talked about before. I think that in terms of community engagement, community outreach, that it's good to set a limit at the beginning with the elected official or the department you're working with, because you can have an infinite number of meetings and not convince the neighbors that they should love you, but respond to the legitimate questions that they have. Who is doing the talking is sort of a two-way street. Who's doing the talking from your side, and who's doing the talking sort of in the community. And whenever you start on a project to develop housing, you really need to make an investment of staff. Obviously, you're making a financial investment, but you really have to commit. These are very, as most of you probably know, even if you haven't done one, you've heard enough of the stories. These are really, can be very tough to do and very time consuming, and there needs to be more than one person involved in a project. And it's good to figure out who's going to do the talking publicly, and that you really are, everybody who does have the ability to talk about a project or be asked questions, that everybody has the same language. I've had projects where have gotten really tripped up because people describe them in different ways. And as you know, certain types of housing bring about a certain reaction. If I say transitional age youth housing, that brings out a certain reaction. If I say sober living home, that brings out another. If I say state licensed facility, that usually doesn't bring out much of a reaction at all. But the words are really important, and so you really want to be in sync. And not only in sync on what you say, but what you write and what's on your website. You just need, you really need to be very, very consistent. Otherwise, people start coming back at you and saying, this is not what you said it was, or this staff person called it this person called it that, the planning department called it something else. And it's hard to figure it out and to keep control of that. So this is sort of the reality of it. Well, we have the law, but so, you know, why can't we just bulldoze our way through? And that's pretty much because there's a heavy, heavy layer of politics involved. And so you have to reach out and work in that, within that political environment in a way that you feel comfortable without compromising your project. Several other things I want to talk about in terms of just sort of dealing with the whole land use and zoning arena and siting and dealing with the community is one of the things I suggest that my clients do very early on is to write a project description that is absolutely no more than 1 page. And we work very, very carefully on the language in describing the project and using the right language, being honest, but not using any language that will get anybody too excited. And that piece of paper will fly all over the place. Everybody will look at it and see it, so you have to be really comfortable with it. I know David and Margaret did just it's a really good one. It's really concise, gives enough information about a careful, professional selection process of individuals who will be able to be successful living in independent housing in the community, and also says, because this question comes up all the time, no sex offenders. On elected officials and the political process, I'm just watch my time. I'm going to speed up here. I'm just going to let you read through the rest of this because you all have access to the PowerPoint. And this, I'm just going to reference that there is a really great outline that is on the nonprofit housing's website, which is 6 steps to building a community support. It's just a really great roadmap on how to move forward on a project. I highly recommend you looking at it in the future if you're going to develop something. Pamela talked about reasonable accommodation. Reasonable accommodation also applies in the land use and zoning context. And it's the same, it's a very similar analysis. Has to be housing specifically for people with disabilities. There has to be a need for the accommodation to make this housing available to people with disabilities. There can't be any financial or administrative burden to local government. And then what usually comes up from local government's perspective is, well, it's a fundamental alteration of the zoning code. And that's also an argument that doesn't work in the land use and zoning context, because what you're usually doing is asking for an exception for one piece of property. The case law is very supportive of using the reasonable accommodation process in a land use and zoning context. Here's just a slide which compares reasonable accommodation to the CUP process. The best part of reasonable accommodation is there should be no public notice and no public hearing process. That's why I work with my clients that way and not through the conditional use permit process. Here are examples that you can look at of how you can make a request for reasonable accommodation for these types of exceptions. I would just like to talk about this for 2 seconds on discriminatory conduct. I have never read anything doing a training, but this is language from the Department of Justice, which was the San Jacinto case, which I mentioned before. The facts of this case are so outrageous, I could not have thought them up myself. It's a real case. It's settled. It was filed in 2010, and it settled in 2014. It involves this little town of San Jacinto, which is either in, I think it's Riverside County. Riverside? Okay. Oh, is anybody from San Jacinto here? Okay. I'm sorry. I just got to do it. It's a really important case, and the Justice Department feels that it has not gotten the kind of attention it needs to make people aware of fair housing laws. So here's how the Justice Department describes what this case was about. And let me just say, it was a group home ordinance that was on its face neutral, but was only being applied to homes, group homes for individuals with disabilities that was not subject to licensure. The city's enforcement efforts included an early morning sweep of unlicensed group homes for persons with disabilities by city officials in November 2008, including the city attorney, representatives of the city's code enforcement and public works departments, as well as armed and uniformed law enforcement officers of Riverside County Sheriff's Department acting as agents of the city. The officials arrived at the homes unannounced and without warrants and interrogated the residents from a prepared questionnaire targeted to persons with mental disabilities. The questions included whether the residents were or ever had been drug addicts or alcoholics, whether they suffered from any form of mental illness, and if so, what type, whether they were taking psych meds, and if so, what kind, whether they or residents were currently using illegal drugs or alcohol, whether they were on parole or probation, and whether they were registered sex offenders. No warrant, into the house. Owners weren't there, just the residents. I suggest you read the summaries of the case, or the case, the settlement of it. It's online. It indicates precisely, the kinds of prohibited conduct. And so you want to be aware this was like a real life thing that happened. Ending on a positive note, I would say that, we need a lot more housing. The law is pretty much on our side in terms of doing it, but it takes a lot of effort and focus. Thank you. Sorry.
Are there any questions or comments?
I have what I hope are a couple of quick questions. One is the 6 and under rule. Does that only apply if it's a licensed facility? Because in California, for instance, transitional housing, sober living, whatever we want to call it, there's no licensing mechanism for. So are there any laws that would that fall under that one that you wouldn't need a use permit?
Well, okay, so the state preemption statute applies to state licensed community care facilities. Oh. Okay, applies to state licensed community care facilities and state licensed alcohol and drug programs.
Okay.
6 residents or fewer must be treated like a family, any other family use, and cannot be subject to additional requirements, not be considered a business, it's considered a residence. So the reason I brought up the Adamson case is because there are plenty of other types of housing for people with disabilities that are not subject to licensure. And so those individuals have a right to live together. There's no cap other than the state neutral occupancy standard, based on square footage.
Square footage.
Right. Okay. But I'm glad you raised this because I talk to a lot of cities that think that 6 and under rule applies to every type of housing.
That was certainly my impression, so I'm glad to get this straightened out. The second quick question is, did I hear one, I forget which one of the attorneys I thought said something about that you cannot have rules for a whole house, that they have to be alcohol, tobacco, and other drug-free, or any part of that?
Oh, I think it was me. Thank you. I think it was me saying that in permanent supportive housing in particular, you can't have a situation where you're going to lose your lease because you don't comply with treatment. It's the definition of supportive housing. I'm not sure if that's what you were referring to.
But it is okay to have rules in a supportive housing,
you can have
facility
rules
that they can't use or
you can have rules in a program. You just have to be careful that you're not discriminating against people who don't want to take a particular medication or do a particular type of treatment by making them lose their housing over it.
Okay, so requiring abstinence is not a treatment necessarily. It's creating a safe environment for the people who are in recovery. So
yeah, it can get tricky. You should call Kim if you come into that situation.
Come to Modoc, we're the most northeast corner of the state.
No, I know what you're getting at because I've had quite a few discussions with providers on this. Yeah, so you can call me.
Okay, thank you.
Any other questions?
Yeah, I just got one. Kim, because of, usually when you go to a CUP conditional use permit.
Oh, you were on the brave ones.
Planning commission, and they're usually individuals that live within the city or work within the city, and they've got put there by one of the council persons or so. Just like SB2 says, you can't withhold, and if you do, and it's found out, the state will withhold some money from you or whatever. Is there some kind of Senate bill that can go out that would actually affect cities to say, when you commission people for your planning commission, that they must have a better understanding or interview them about disability? So,
That'll be great.
I'm just wondering.
Okay. No, well, yeah, it would be great. It would be great. I think what we probably need is some kind of funding source to provide training to public officials. I mean, I did a little bit under one HUD grant, but that was a while back. But no, I completely agree that there's a lot more educating that needs to be done.
Rama.
Just out of curiosity, did Riverside pay a big fine? I hope they did.
It was, It was the city of San Bernardino. They borrowed the questionnaire from Riverside. Right, but yes, there was a monetary settlement. Yeah, you can read about it online. Yeah, and it's probably on the Department of Justice's website also.
Anything else? Okay, well, would you help me and applaud for these folks? They did a great job.